Hey guys, let's go over the entire public file in the case of State of Idaho versus Brian Kohberger. It starts with a probable cause affidavit. Everybody's looked at that by now. I glanced at it for the first time in the video yesterday. Read it again the second time, and it was much more compelling reading going through it carefully. From the efforts by the police to track down the vehicle involved, which was very successful, very good work, and then the telephone involved and how that tied to the vehicle and to where the crime occurred and to the person who they thought may be involved, to finally the DNA they recovered on the sheath that contained the murder weapon and how they tied that to his family's DNA, so that there was a 1 in 500,000 chance that the person who left the DNA on the sheath was not the son of the male at Kohberger's residence, his father. So 1 in 500,000 chance that it could be somebody else. Now, since then, I'm sure they've gotten his DNA, or they will be, and they'll be testing that against the sheath DNA itself, and then they'll be able to make a direct match. The 1 in 500,000 chance of the father to son is not, if that sounds low, it's not, because there's typically not a perfect match between the father and the son. And so the odds are never going to be perfect. They may be 1 in a million, 1 in 500,000. That's very strong indication that that's the person you're dealing with. Anyway, the probable cause affidavit was simply to get probable cause for an arrest, and it was successful in that a probable cause order was entered. So this was done pretty quickly after the DNA was secured on the 27th, processed on the 28th, affidavit filed on the 29th, and the probable cause order and arrest warrant issued on the 29th. The probable cause order noted that there would be no bail in this case, at least to start with, and there probably won't be as it moves forward. Following the probable cause order was the arrest warrant, and that was signed on 12/29 at 2:22 p.m. Idaho time. And it noted that there'll be no bail, and the person would be committed to the sheriff of the county of Latah, state of Idaho. The very next day, you start seeing some activities by defense counsel in this case, including a limited notice of appearance by Ann Taylor, appearing on behalf of Brian Kohberger. Then her notice of invocation of rights on behalf of Brian Kohberger, that he's exercising right to remain silent in all of his rights. Nobody's supposed to question him. I think she also did that in her limited notice of appearance. That's following the order of the appointing of the public defender on the basis that the defendant is indigent, so the state would sponsor counsel for him. Same day, defense counsel made a motion to preserve the crime scene and evidence. So you remember they were about to clean up the house and return that to the house owner. Well, she made a motion, hey, preserve that and other evidence. And in her motion, you'll note that she does ask for the residence to be secured, but also any other evidence as well. But she notes that she wanted to be able to take a view of the scene to effectively and constitutionally represent Kohberger. And it's certainly reasonable for defense counsel to say, hey, put the brakes on this and let me get over here and take a look at it now that I'm in the game in this thing. The court did issue an order and ordered the state to preserve samples and evidence collected or generated, such as bodily fluids, blood, tissues, notes, slides, etc. It would be held and preserved by the state. But as far as the house goes, the court was more specific and said that the home, outbuildings, trailers, vehicles, etc. would be locked. Crime tape will remain. No on-site police presence required, and it would be preserved until February 1st of this year, unless the court further orders otherwise. So this may get returned back to the owner at that point. I think the defense counsel has been out there, so it's not a case where they're just going to hang on to somebody's real property forever. They'll have to deal with this at some point. So then Kohberger's lawyer, Ann Taylor, makes a motion to the court, or a stipulation she provides to the court for this non-dissemination order, which we're calling a gag order, to prohibit attorneys, investigators, law enforcement personnel from making extrajudicial statements about the case, other than if they're quoting from something in the public records of the case. And note that this is signed by her, but also signed by the DA, the prosecuting attorney in this case. So this was a stipulated situation by both sides of the case. And then the court issues that order saying, hey, don't anybody talk about this. But the court didn't do that sua sponte on its own. It did that at the request of the parties in a stipulated format. Now, about something like a gag order or a non-dissemination order or whatever, remember, this is not a national decree that binds everyone. Typically, the order is going to bind the specified entities only in the order, because they're the subject of the order. This isn't a law that's being created. This is an order to particular entities or people. So it's going to need to be those people. Those people would have to be typically in the jurisdiction of the court. This court is not a national court that controls everything that occurs everywhere. And then also typically the order needs to be served, because how can you obey the court order if you weren't given a copy of that to know what your obligations are? So sometimes I see people saying, well, what about this person in Pennsylvania said this, or an FBI agent said something somewhere? It doesn't mean that they're violating this court order at all. So then the court gave a notice of how it was going to govern courthouse conduct. And that included how it would deal with the media, which is how it did do, which was, at least currently, it allowed a video feed to be provided to media, but not live from the courtroom. So the proceedings were shown, but they were on a delay. Then there was the notice of hearing, which if you were interested in the case, you saw that, where Kohberger appeared in court and said he did understand what the judge was telling him when she read off the charges and also his rights. And then I think they're going to reconvene on the 12th. For a status conference to see what's coming up next. Some of these things in the future they may waive on the defense side just because they don't want more of the stuff being talked about in the public if they don't think there's any real way to contest it. At that hearing, the video I watched it, I was watching the defense attorney, and props to her for a very professional presentation. She wasn't putting her arm around the guy or acting like she was suddenly his best friend or whatever, which you see sometimes in a very manipulative way defense attorneys will do. Instead, you shouldn't be going around the courtroom hugging everybody and stuff like that. She was very professional in her demeanor, in my opinion. And even when she said she wanted to make a request for bond, she said this is a limited request. And I think she just made a comment that please take notice that he has a supportive family. And that was decent of her to do, I think. And it wasn't designed to be inflammatory or exploiting the situation. So I understand from some things I've seen that she's a skilled attorney, but I have to say, at least on this one situation, I've seen her in court on this case, I like how she has started off in terms of the dignity that she's brought to the situation. It's very sensitive, and I don't think it needs to be turned into a circus by any of the parties involved. In some cases, you've seen defense counsel do that, where they almost like they have some kind of personal relationship with the defendant and the way they behave. And she wasn't distant from Kohberger, but she wasn't acting like that they were long lost people and he was a sympathetic puppy or something like that. So I appreciate that. So that's the whole file that's in the public at current, nothing else. So if you're one of the bound parties of the court's order, these are the things you can speak about and nothing else until other things come out, which it will as the case moves on. But in large part, it won't be so much in public. And I think that's okay. The proceedings are being shown by the court. The public is advised about what's happening in the case. That doesn't mean that there needs to be wide open interviews and public relations campaigns by either side. They're not doing that. So I think the police investigation under the probable cause affidavit was excellent, just excellent. And the probable cause affidavit, it's very strong and it's well done. It's not perfect, but it is way past the minimum necessary to get an arrest warrant and closer to, yeah, this is for sure the right guy. Now they're going to bolster that with more evidence or not, and depending on what the defense brings up. But to me, it looks like this guy's goose is cooked, and maybe she can negotiate the death penalty off the table, and maybe she can't. But I think they got the right guy, and they have the evidence on him. They'll have more evidence on him. If this was his first crime, hopefully he won't get the chance to do another one. Thanks. Bye.